And yeah, thanks again. And next up, thanks, Mark.
Thanks, Harry.
All right,
Bye-bye.
next up, we have Robert Baugh, and Robert is going to be talking to us about Brexit and all kinds of interesting things over there. Take a minute to, I don't know, we're going to trash the Tories for a minute or something. I don't know, right? Yeah. So I'm going to give it to you and let you take it all away. Oh, man, you're going to start with that dress? Oh, come on. Oh, man, starting with the debate already. All right, take it away, Robert.
Thanks very much. Yeah, so I thought this was actually a good photo for this. So I tested my family on this. Do you see it as blue, black, or do you see it as white, gold? And it went viral in 2015 and actually led to academic studies about why people were seeing it in two such different ways, and all these different theories came out. So I thought it was a good analogy for the question of, well, with UK GDPR reforms, is there a genuine Brexit bonus that the UK is chasing here, and a necessary one perhaps? Or is this all just Boris bluster? Is this just the Tory Party chasing White Cliffs of Dover votes? So I thought it would set up the conversation quite well. So, but the first thing really is, well, what actually is Brexit? And unhelpfully, the Prime Minister at the time in 2016, we're now on our fourth Prime Minister in 6 years, said Brexit means Brexit when asked that question. It became such a famous phrase and was discussed very, very much. And the then Information Commissioner, Elizabeth Denham, said on the BBC radio, I don't think Brexit should mean Brexit when it comes to standards of data protection. And I think this shows, like that dress in a way, that there's sort of dichotomy of views. You've got experts and practitioners going, we want certainty, we want harmonization, we want interoperability, we want that sort of standard of protection. And you've got the political will about, well, we're having this Brexit and not really knowing what it was. And there's a lot of arguments about the vote on Brexit, about how many people who voted for it really wanted it or were protesting and all that sort of stuff. We won't get into that. But the Tory Party has been sort of in power since 2010, and they've still not really found an answer to what Brexit fully means. So looking at some of these statements, the early statements were actually pretty good. So this is a document on the left from 2017 that the UK government created for the discussions with the EU. So just on the timeline, obviously GDPR went on the statute books in 2016, and it came into effect and applied across everywhere from 2018, including in the UK. So the Brexit vote was also in 2016, and then we didn't formally leave until the beginning of 2020. And there was a transition period to the end of 2020. So we're right in between both the Brexit vote and GDPR going onto the statute books, and then Brexit taking effect and GDPR having effect as well. So a great opening comment from the government in an official paper that 75% of our cross-border data flows are with EU countries. So it's essential when we leave the EU that we avoid regulatory uncertainty, which I would say that they've done a spectacularly poor job at doing since then, sadly. It's been a roller coaster of uncertainty. In 2018, Theresa May gave a speech to the then PM at a Munich security conference and said that our data protection bill that became the 2018 Data Protection Act will ensure we're aligned with the EU framework. But we want to go further, and there was a lot of talk about the UK ICO still being involved with the EDPB, still being involved in the regulatory aspect in Europe. So all the talk here was about certainty, and it was all about very close alignment, even more than an adequacy decision, a bespoke arrangement to reflect our exceptionally high standards of data protection. Don't forget, we're the only country that's left the EU with the GDPR in place. And so Britain would be at risk of moving away, whereas all the other countries are all trying to move towards Europe for the adequacy. Those statements, though, those early statements turned into recent statements post-Brexit, which are stressing the differences. So from the consultation paper, the Department of Culture, Media and Sport, DCMS consultation happened in September 2021. So again, just 3 months or so after we got our adequacy decision, saying, well, now we're out of the EU, we can reshape our approach to regulation and seize all these opportunities with new regulatory freedoms. And we'll come back to those opportunities in a second. And the one on the right is the most recent one from this month from the Conservative Party conference from the DCMS Secretary of State. Now, in this period of time, we're now on our 4th Prime Minister. So Liz Truss came in, and you'd have all been aware of the exchange rate issues that the UK has been having, and the increase in public spending by the Bank of England, buying government debt, etc., etc. So this is the sort of context within which the Conservative Party conference has taken place. And the Secretary of State for DCMS said, we inherited GDPR from the GDPR. Actually, the UK was very influential in also the drafting of GDPR, and obviously the Data Protection Directive was there basically in our law from the 1998 Act. And the bureaucratic nature of GDPR is limiting the potential of our businesses. The Secretary actually referred to an Oxford study saying that businesses were 8% low on revenue, but even the authors of the study said, don't rely on this because it's a sort of finger in the air job pretty well. A bit more than that, but there's a lot of reasons why you shouldn't rely on this, and there's a lot more to go move this forwards. Also, this is one of the things with the governments at the moment. So basically, the UK government says here through the Secretary, small organisations are forced to follow a one-size-fits-all approach, the same approach as a multinational. That's just not right, and it's not conservative. It's also just not right because GDPR is full of the word appropriate. You look at the UK ICO website, it's full of things like if you're a small organization, you do this. If you're a large one, you do this. So it's not one size fits all. And then this amazing quote in blue here that's being commented on a lot, that we've got shortages of electricians and plumbers and GDPR is tying them in knots with clunky bureaucracy. So that's just a bizarre comment, really. But this is where we are with the political discourse. So let's try and draw out some of these Brexit bonuses that we're chasing here. So from the consultation, the response to the consultation, and also the statement launching the bill on the left with the white background, reducing burdens on businesses, fantastic. Unburdening businesses from prescriptive requirements, great. Driving growth, innovation, competition, making businesses more efficient, higher productivity rates, more jobs. These are enormous targets and really specific. Higher productivity, more jobs, make more efficient, get rid of prescriptive requirements. On the right, some more from the talk on 3rd of October at the Tory Party conference. Simpler and clearer, fantastic. No longer be shackled by unnecessary red tape. Let's remember that for just a moment. And then also seizing this post-Brexit opportunity fully. They've been hard pushed to find Brexit bonuses, but we can be the bridge across the Atlantic and operate as the world's data hub. So that's another one just to remember as we go in. And I am actually pretty sad to see the sort of level of political spin that is on this. So this is an actual press release on the government website from the 5th of July, 2022. Marking a discussion, an agreement with Republic of Korea, South Korea, for the first adequacy decision in principle since leaving the EU. Look at that sentence on the right there. It's sees the government seizing the benefits of having independent data laws. Now, what benefit? Because the EU GDPR adequacy decision was adopted for South Korea on the 17th of December 21, over 6 months before. This announcement is about the decision in principle. So similar to the EDPB reviewing the decision, we've now got the ICO reviewing that decision. So 6.5 months later, an agreement to agree isn't as good as having the agreement back before. So talking about timelines, just a quick reminder of where we are on the timelines. So UK GDPR applied from the 1st of Jan. It's essentially identical to GDPR from the EU. They've just crossed out the EU written in the UK. We got our adequacy decision, the first with a sunset clause, due to the concerns about the direction the UK was going to move. 3 months later, the consultation came out. It was a 2-month consultation. In June, the government came out with a response, which was much more slimmed down from the consultation. And then very quickly, really, the DPDI Bill, the Data Protection and Digital Information Bill, was introduced. And it's quite a complex bill, so they must have been working on this for quite a while. It went through the first readings in Parliament. We have sort of first, second, third readings, etc., in the different houses. And it was pulled on the second reading. And part of this was because it was the day before Liz Truss took office, and it was the last day of Boris. And everyone's saying, well, is that pulled and gone or not? And then we had the conversation, the speech by the Secretary of State at the Tory Party conference. It could be binned. Is there a new consultation period ahead? No one's really sure. But we do have the Data Protection and Digital Information Bill. And this is the cover of our Keepabl guide to it. And we're going to look at 2 particular areas from the guide, RoPAs and the DPOs and senior responsible individuals. So let's get into a bit more detail now. So this is about, as you can see on the left, RoPAs for controllers, records of processing activity. Now, remember those benefits that we were talking about simplifying, getting rid of restrictive requirements, unburdening businesses. So on the left here with the light blue, you've got the UK and EU GDPR requirements. You can see Article 31 with A, B, C, D, E, F, G. On the right there, you've got from the DPDI bill, we put the same thing level with the same thing. So it's slightly different order from the bill itself. But you can see at the top, for the EU and UK GDPR, who are you, and put that data down. Obviously, that's going to be included in the DPDI bill. Purposes, it's exactly the same. Data subjects and personal data. So in the EU and UK GDPR, it's the categories of data subjects, categories of personal data. On the right, it says where you process special categories and crime data as well. But don't forget at the top, you've actually got to keep the information about the personal data you're processing. So you're going to have to know what the personal data categories are and who the individuals are as well. Recipients, identical. Transfers, identical. Retention, identical, potentially even more strict, saying the actual period. We'll see whether you can put a formula to calculate it or not in the way that people do now. And security, identical. So to me, this is really belying the whole process of emperor's clothes here, and that it's Boris Bluster, because this is exactly the same to me. Now, going on to another one of the accountability landmarks, the data protection officers. So on the left, again, you've got the UK and EU GDPR requirements on data protection officers. On the right, you've got the new DPDI bill requirements on the senior responsible individual. So public sector, identical appointment requirements. It's different for the private sector. Now, I do think the DPO is misunderstood in GDPR massively. So not that many companies need a DPO. It's become a bit of a shorthand for privacy expert. So if you look at it, the controller processor designates one where the core activities on a large scale, a systematic monitoring of data subjects or processing of special categories and criminal convictions. So the Law Society of England and Wales, in their guidance to the law firms in England and Wales, said you're likely not going to need a DPO, and that's even law firms with what they do. It's core activities, not ancillary like your own HR, etc. Now let's look at the DPDI bill. You appoint an SRI, a senior responsible individual, when processing is likely to result in a high risk. Now this is really interesting. So it's obviously a very different approach. So arguably it's the same test when you do a DPIA. But in this situation, does it mean everybody has to have one or no one has to have one? Because under the GDPR, you're not meant to do high risk processing. What you do is you do your DPIA if you think it's likely to be a high risk. You put measures on, you reduce down the residual risk. If it's still high risk, you discuss it with the regulator if you can't still reduce it down. And the regulator might say, no, you can't do that processing. So you're not meant to do a high risk activity. You're meant to put in place measures to reduce that risk, say, down to medium. So if that's the situation, then very few people will need an SRI. But if the idea of this is, well, it's like the DPIA, does it potentially lead to a high risk before you put your TOMs in place, your technical organizational measures, then that would catch more people. But then that's not what this actually says. So again, uncertainty. And then in terms of who can be the DPO and who can be the senior responsible individual, we're all quite familiar with who can be a DPO. They've got to have a certain level of expertise that's relevant for the organization. They can be internal or they can be external. Under the DPDI bill, they have to be part of the organization's senior management, which means people who play significant roles in making decisions about the whole or substantial part of the activities. Now, this brings me on to the conflict part here, because that means they're going to be conflicted, because you can see here on the top right where the performance of a task would result in a conflict of interests. The SRI must secure someone else does it. Well, if the SRI is going to be a senior person affecting what the business does, there's a legion of decisions recently and guidance that if you're head of or you're senior or you're acting in a controller in some way, you're conflicted in being the DPO. So by definition, the people they want to be the SRI are going to be conflicted and they have to push it down. So again, more uncertainty. I think personally, it would have been better if they just took away the conflict. I think that would just help DPO and SRI a whole lot. Just going back to the tasks then. So let's assume you do need an SRI and you do need a DPO. So under the new regime, if this bill goes through, what actual tasks are they? So you can see again on the left, the UK and EU GDPR advising, monitoring, training, and liaising. On the right, under the DPDI bill, advising is pretty well exactly the same. However, there's an interesting wrinkle here. You can see there it says under advising, informing and advising the controller, fine. Any processor engaged by the controller. Now, Does that mean we're all going to be writing to Microsoft and Google saying, when you're doing Office 365 and you're doing Google Workspace, I want to inform you about your obligations and advise you on it? That's quite an interesting addition in there. Monitoring and training, pretty well identical. Liaising with the supervisory authority, pretty well identical. And then there's some extra bits. Complaints, breaches, again, how can you not be conflicted if you're dealing with the complaints and the breaches? You could be advising without being conflict potentially. But ensuring compliance is really interesting. It's a statutory obligation on this role to ensure that the controller develops, implements, reviews and updates measures to ensure its compliance. So that's not there for the DPO. So the SRI has a statutory obligation to ensure compliance by the organization. Now, what's the liability of the SRI on this? Because it's clear under the GDPR that only the processor, only the controller have liability. It's likely the SRI doesn't have liability, but this is a bit of an interesting bit of drafting. Again, more uncertainty as well. So what do practitioners think? So we did a survey on LinkedIn. We got 79 responses, so not too many, but if the government can look at non-statistically relevant studies, so can I. And most of those, all those 79 were all involved in privacy. And so we asked RoPAs, DPOs, DPIAs, DSARs, all the sort of accountability bits, what do you think about the proposed changes in the bill? So only 21% thought it would be easier. So that's only 1 in 5 thought it would be easier. Twice as many thought it's going to be harder. So that's pretty crushing. And twice as many thought no real change. So 4 out of 5 say actually it's going to be no real change or harder, which is pretty tough. So what do the legal experts say? So Ashurst is the firm I qualified at and stayed at in my early days as a lawyer. It's a very good city firm. They had a round table with general counsel and data protection practitioners and DPOs, etc. And they asked a series of questions. And the last one was, what about the reform of the accountability network? Members discussed it. They said, look, it's going to create extra red tape, bureaucracy, costs and resource, which the bill was meant to be trying to avoid. They didn't really see any benefit to consumers. I would agree with that too. Of particular concern to that panel was more detailed records of processing than the requirements of GDPR. The overall consensus was it wasn't the answer for reducing burdens on business that it had heralded to be. Again, this is that, is it really a Brexit bonus or Boris Bluster? And so if you're a global business, you're going to have to do EU GDPR probably anyway. And in fact, in that government paper in 2017, the government even said, look, a lot of UK businesses, because of all that trade with Europe, they are going to have to just comply with EU GDPR anyway. So it makes sense to be really tightly together. And this last paragraph says, well, you know, it's really redundant or futile for global businesses and need significant resource, times and efforts to implement these changes, which are mostly in name rather than in substance. So a pretty clear view. You can look at lots of other law firms on this as well. Here's another one, which is more like the blue, black or white gold dress. This is DAC Beechcroft. So it's neither a close mirror of the existing obligations nor a radical departure. And we won't read through all of that, but you can see at the bottom, it says, does it strike the right balance or end up satisfying no one? These slides, I think, will be available later on for people as well. So you can see that they're sort of saying, well, it's moved here, but it's not moved here. And so it sort of pleases and annoys everybody. So what about the EU? So this on the left was what the EU did when we got the adequacy decision. There was actually members of European Parliament passed a resolution in the European Parliament urging the Commission to amend its adequacy decision for the UK. This was in June 2021. We got the adequacy decision in 28th June, 2 days before the transitional period, always giving us heart attacks. And you can see here, onward transfers of data to other countries was a key concern. And if you remember that comment from the Secretary of State from DCMS being the bridge across the Atlantic. So, you know, this is all quite interesting. There's a lot of discussion we could have about transfers as well. And so if you look at the right-hand side there, this is an answer given by the European Commission to a question around the DPDI bill. So what should happen with the DPDI bill going through? And you can see on the right that basically it will ultimately depend on how the draft bill evolves through the legislative process, which the Commission will follow closely. And in the second paragraph, the adequacy decisions themselves, as well as that sunset, first one to have it, There's tools to react in case the reform leads to problematic divergence under the adequacy standard. And we can talk about the structure of the ICO, for example, as well, which I think does hit that, and also the approach to transfers. The Commission can suspend, terminate at any time, and even immediately in case of justified urgency. So that's always happy. So if not the DPDI bill, then what? So again, from the statement to the conference, they said, look, we're going to look at countries that don't have GDPR, but have adequacy, like Israel, Japan, South Korea, Canada, New Zealand, where our current commissioner is from. And if you look at the New Zealand Privacy Commissioner website, I really recommend it's really good. And the current commissioner is saying, well, look, we've really got to keep our adequacy decision because it's like a free trade agreement. It's an absolute advantage. And it sets out on the website how New Zealand had to move its law towards Europe. So all of these countries, yeah, they don't have GDPR, but every single one has had to move to get adequacy towards Europe and amend the laws and keep an ongoing conversation with Europe and keep amending the laws. There's been recent chat about changes in Israel, whereas the UK would be the only one in history to be starting with 100% alignment and moving the other way. So the next general election is on or before the 17th December 2024. It can be called at any time. It used to have to be in a particular period, but now they can call it any time. If it's all the way through to December 24, which given the raucous in Parliament at the moment is by no means guaranteed, if the Tories lose, then is there enough time to push through the reforms? If Labour win, what would be their position, which is not really known? So also along with this, there's just been introduced a bill to sunset all European origin law, which just shows you the sort of flawed logic that the Brexiters who control the Tory Party and hence the UK government are going through. So I'll finish there and ask if there's any questions.
Awesome. That was fantastic. I'm looking to see if there are any questions over here. Wow, Tokyo, hello. Wow, we have people from all over the place.
Fantastic.
Yeah, right. So what do you think about that dress? Was it blue? No.
So funnily enough, yesterday I thought it was white gold. My son said blue black, and then I was working on the deck later on in the evening, and it was clearly blue black. And then today again, it's white gold. So some of these studies say it depends on whether you spend more time indoors, so you see under false light, which would be the white, you'd see the white gold and see that as blue black, or whether you're more outside and you see it as blue black. So I think the interesting thing there is you can see the dress differently, even at different times of the day. I'm afraid I'm pretty consistent. I think people are pretty consistent on what they think of these reforms, that really you're swapping out one orange with another orange and just calling it something different, but everyone's having to do similar stuff. There's no real change on that.
Yeah, that's what I see happening too. Now, on the issue of the processing and the possibility of someone walking in, a regulator walking in and saying, stop processing right now. I understand there's a process behind that. You can't just walk in and demand stop now. It's more like a temporary restraining order. You got to get a process, but does that really serve as a deterrent for businesses?
So
you gotta get caught first, right?
Yeah, I mean, not really. So the UK ICO is, I think, justifiably very respected around the world as a very practical, knowledgeable, well-meaning regulator that produces very practical guidance and tools for organizations and is very keen to help people move forward for compliance. I think where they're less respected is on their enforcement. There's a lot of enforcement on PECA, and we can talk about the changes to PECA as well, including cookies and including the levels of fine. And they do fine quite regularly on PECA, but very irregularly on GDPR. And the Information Commission has doubled down recently with a statement that, look, we are really looking to work with people to get them moving forward. So to get a statement, an order, a notice from the ICO to say stop processing, there's a very long road before you get that.
Yeah, I would say, I've been telling businesses, fear the French, and I've been telling them that for a long time, because the canola is no joke. Do you remember when they gave the threat, we're going to start looking at your cookies? You remember that? Then they may or may not have even looked at some businesses, but there was a credible threat of enforcement. And that was enough to get people nervous enough to start making phone calls going, what do I do now? I fear the French, like you said. So
yeah, I mean, they wrote to the top. They wrote to the top 100 websites, if not the top 1,000 websites in France, and said we're going to review your website in 3 months. They've also done all those fines on Google and Amazon around cookies in the tens of millions of euros. So yeah, I totally agree. I do think it's right that it's the last thing that happens where the regulator says stop, and there should be a process until you get there. I think I'm a big fan of CNIL. I'm a big fan of the UK regulator. I don't think they're massively different. I think CNIL is seen as having more teeth and happier to push forward more on enforcement in the UK ICO for sure.
I got a question. Do you think that the new commissioner will be looking for a logical approach here, or do you think he's being messed around by the Brexit brigade?
So I'm a big fan of the new commissioner. I think that he's got a very difficult tightrope to walk, because it's a great role to have. You know, you're very influential in UK data protection practices. And looking at what he did during lockdown, for example, the New Zealand commissioner came out with a privacy seal, privacy friendly badge that they reviewed, not just technology solutions, non-technology solutions as well, around things like whether you need to, you know, how do you log people coming in and out of a pub or something like this during lockdown. And so the UK just wasn't doing it at the time, and there was a lot of uncertainty here about when you had to do it, because it wasn't a statutory obligation. It was a you can do and you should think about it, whereas in New Zealand it was an obligation. So I think the commissioner is very focused on practical compliance. He's also come from that country where they've been moving their law towards GDPR, but it is not fully GDPR. So yes, he knows logically you don't have to have exactly GDPR to have adequacy. So does he actually think at the end of the day, because we're in Convention 108 and 108 plus and stuff, we've got legally binding international treaties saying the UK must have laws that do this? Well, you're going to have protection. You can't really whittle stuff down too much if you're going to meet the obligations under Convention 108, 108 plus anyway. So I think he's sort of thinking, well, that's not my job. My job is to help businesses comply with whatever the law is. And he probably thinks, well, they can't really butcher it too much anyway, which is one of the things we've seen, even with what they've come out with all the rhetoric. There's, you know, I think it makes it harder for people in the UK, and then they're going to have to deal with two different regimes.
Yeah, absolutely. Yeah, COVID taught us a lot. And I think that if anything, it brought to fore some of the harms that can result when you don't properly plan data collection exercises.
Yep.
You know, yeah. Yeah,
Yep.
because people collected a lot of data. We still have that data sitting around right now, and it wasn't properly collected, even with us knowing everything we do now, because it was hastily collected. It's sitting, waiting to become a problem. I know. Yeah.
I think also there was a benefit from it in terms of there was a massive awareness of data protection. I mean, I've been doing data protection since 1993, and you know, until GDPR came along, people were just like, yeah, whatever. And you'd be advising customers and clients as a lawyer, and they'd go, well, you know, if I did all this, I'd never get any work done. And what's the highest limit? Well, it's 500K. Well, forget about it. How many people have been fined? Well, okay, let's ignore it. Then GDPR came along. The rules are pretty well the same. It's just the fines gone ballistic. So suddenly everyone's scrambling and looking at these rules. And GDPR is by no means perfect, but I do think that one of the benefits of that period is the awareness of GDPR. So everyone was talking about it. You know, talking about it in the pub. Like, how are you going to do that data? They may not have been saying GDPR, but they were like, do I want to give you that data? What are you doing with it?
Yeah, absolutely. Yeah, if anything, it brought people's attention to what is being collected and what can be done with it. So that was fantastic. I am not seeing any other questions over here. Just a lot of praise for how good the presentations are going so far. So I know, right? We're doing it. We're pulling it off here. One last question before you go. Liz Truss. Is she going to make more of a mess of this, or is she even going to be there long enough? People are kind of mad she killed the Queen and all.
So I've got to be so. My personal view is her and Kwasi Kwarteng have made just mistakes on economics that A-level students wouldn't make. Supply side economics, trickle down. It's, you know, there's London School of Economics study quoting tons of others. It's never worked all the way through the Reagan times. It only increased disparity in wealth, and it didn't help any of the poor. It helped all the richer. So they're sort of stuck in this. They did a book called Britannia Unchained with a few other far writers, and unfortunately, I think that it's so hard to know, and it's not what we need at this situation. They've done a U-turn on the top level of tax. They're doing a U-turn about windfall tax. That's coming through. Will they do a U-turn on the bill? I mean, to say we're going to get rid of all EU-based law at a cutoff date, where's the logic in that?
Yeah.
How is that? That presumes all EU law is bad, which is just not common sense or logical. So, and could they actually implement? They haven't been able to implement the DPDI bill or the online harms bill, and so they'd only give themselves 15 months to implement all replacement law. It just beggars belief, really, unfortunately.
Yeah. I think only 30% of businesses are GDPR compliant anyway, and those are the ones who are really just being honest. Right?
I do see a lot of I think one of the things that also was mentioned earlier is businesses want to do the right thing, and they want to crack on doing the right thing. What they don't want is uncertainty, and they don't want risk either. So the people I talk to at the moment, most organizations are still trying to organize stuff on spreadsheets. They're all now realizing they need automation. They're wanting to comply with this flurry of privacy laws. They're seeing all the fines come through, but also businesses do want to do this. So, for example, in the very one last comment, in the responses to the consultation, one that surprised me a bit, the British Retail Association response is really, really good. And they also said on Article 22, the automated decision making, which the government said, we're just going to scrap that so we can do AI on everything we want. And the British Retail Association said, please don't scrap that, because it's a really cornerstone thing for trust. And actually, if anything, make it tougher, please. And so most of the responses came back saying, don't get rid of that. Please keep it, because it helps with trust. So I do think that businesses do try and do the right thing.
Yeah, excellent. Thank you so much for that. All right. Well, that was great.